Adjournment request, if any, from item number 1 to 6.
May I please your lordships? One affidavit has been filed by the GMC authorities in item number 2. That may be requisition.
That may be.
Requisition. If you will.
Item number 7 to 16. Item number 17 to 31. Adjournment request.
Item number 26, 27, and 28.
Yeah.
If the matter should be taken up of the vacations, the department has written a letter to the labor department asking for the pay that can be fixed for the petitioners. They're just asking an increase in the pay because they're tutors and a fixed working and a fixed pay.
Tutors and some.
We are taking some steps with the labor department to find out what can be the.
So you are supposed to give some relief to them.
Yes, once we get some instructions from the labor department, labor welfare department, who says that this can be fixed, is when we, the education department, can propose and have it done. They have not challenged what they are getting now.
You are for the,
But at least for the petitioners.
who do you want? Okay. The concept of the, Mr. R. Majumdar, the concept of the education department has submitted the matter regarding the better pay scales, regarding payment of better pay scale to the petitioners is under active consideration with the state government. Therefore, he prays some time. He prays for adjournment. Let's start to puja vacations.
I'm a pleasure.
May it please your lordship. Lordship, in item number 30, lordship, the respondent has filed their affidavit, lordship. We need some time to file a reply, lordship.
Yeah.
After vacation.
Yes.
May I please your lordships? Lordship, I beg to mention item number 23, lordship.
Clear here.
Yes, lordship.
Yeah.
Lordship, in this matter, your lordship may not be take up this. matter.
Another bench.
Me, I can't.
Yes.
Obliged, lordship.
From item number 32 to 43.
Other side, I beg to mention item number 32. After vacation, in this, I have to file a written reply. 30.
One category is the resident of down. Nothing. Registration for vacation. So,
Yeah, what do you want?
After
What do you want?
after vacation, your lordship. After 2 weeks, your lordship.
You are for the,
I am for the appellant.
that's one, the plan pays for an adjournment, list of puja vacation, interim order if any to continue till next.
Obliged. May it please your lordship, I beg to mention item number 34 and 41 to 43. Lordship, we have sought consent from the other party.
34.
34 and 41 to 43. 41 to 43.
Matter is pending in the Supreme.
This issue is not resolved with this insertion of subsection 5 in section 16 in the latest finance bill.
Lordship, I have instruction to seek an adjournment. I am representing on behalf of Mr. Amit Goel, and Lordship, due to some
You have,
personal difficulty.
you have what?
I'm for item numbers 41, 42, and 43.
And who is appearing in item number 33? 30, this 34.
Yes, Lordship.
Who is appearing for the respondent in 34?
Standing Council of Taxation Department. Lordship, consent has been received.
Next week. 34 next week. And 40, 41, 43 after puja vacation.
Much obliged.
41, 40.
40, 41, 42 and 43. Okay. Yes.
Any other request?
Lordship. My lord, this is eviction matter. My lord, anytime we may be evicted.
So we have filed writ appeal. They kindly be listed on Monday.
Monday.
Obliged.
May I please, Lordship? Lordship, by taking consent from the other side, I beg to mention item number 40, Lordship. Lordship, my senior is out of station. Lordship, may kindly adjourn the matter for.
Arjan,
May I please your lordship? I beg to mention a writ petition for listing under admission against the order passed by the learned Central Administrative Tribunal. Lordship, if a matter may be taken up on
When is
Monday,
it?
lordship.
Lordship, I am seeking listing for one I, your lordship. It is for condemnation of delay, your lordship.
how long delay? You were listed in the due course.
No, notice has already been issued, your lordship, thereafter it has not been listed. Last it was,
served or not?
notice served here.
It is served.
Notice served, thereafter I have filed additional affidavit.
Witness. Daily list for orders item 1.
Now she is cooked. Married and working. Take some. A bit like. So she's saying that for that period, the mental health it's fine. But here it says it's required from the central website, is 47. Eight between.
Why don't you approach the Meghalaya High Court?
Lordship, I'm on that part of the, because order was of the CAT. Then I filed a review before the CAT.
Fine.
Proportionate share, lordship. I'm not for.
Against the
because-
order of the CAT,
Yes,
which
Lord.
you sought review, already that High Court of Meghalaya has affirmed that order.
This is only on the proportionate share of the mother in, means of the
But
grandmother.
it may be the family pension, widow of that deceased employee.
Yes, lordship.
She filed an application before the CAT.
Yes,
The CAT has allowed that application,
yes, lordship.
against which the mother of the deceased employee has filed a petition before the Meghalaya High Court.
Yes, lordship.
Meghalaya High Court has affirmed that order of the CAT. Now you have filed a review petition after that. And even though that review petition is filed, then essentially you should approach the Meghalaya High Court, not this court.
Lordship, may I submit lordship? As for
And
my,
what is the relief now you are claiming here?
it's the proportion which she was entitled, because when we filed, she was unmarried. When we filed this application
you are
before this,
married.
yes, now she is married, but
And working also.
now she is working in a private company, lordship, with a meager. But at that relevant point of time, when she has approached before this honorable court, she was unmarried. She was unemployed, lordship. Proportionate share which she was entitled at that.
Satisfy us on regarding the maintenance. Because the dispersing authority or whatever it may be, that is in the Meghalaya. Certainly this Guwahati High Court has no jurisdiction to entertain.
With regard to that lordship, because I have filed and because I should have made a party in the original
So that's altogether
application.
different, that your whatever the prayer,
Yes, lordship.
that has been now decided by the tribunal rightly or wrongly. If you are aggrieved by this order of the tribunal, you should approach the Meghalaya. Not this.
But for that reason, because on that count, I have approached this because I have filed an OA. I was not
The
party.
earlier OA was also filed here only.
Yes, lordship. And
That
then,
order was challenged pertaining to Meghalaya. All the authorities, all the whatever the transactions regarding payment of family pension are to be made in this Shillong, not in Guwahati or not in state of Assam. Then yes, the separate high court is there, you have to challenge that before that court.
Because since 18, the notice was issued.
What is it mean? The 18, if it is not maintainable, not maintainable.
Yeah, I understood, Lordship.
We don't
On
have
the
the jurisdiction.
maintainability point, that
If
let
we
me
don't have the
be
jurisdiction,
given some time.
so if it was
So,
filed in
I
2008,
understood,
how
I
can we
understood.
gain the
That I'm not arguing, Lordship. So on that count, let me be given some time so that on maintainability part, I will argue, Lordship.
This writ petition is filed by the petitioner, being agreed with the order dated.
Impugn order is of 11/7/2017, Lordship.
11
No, 27/11/2017. 27, annexure 1.
11/2017,
Yes, Lordship.
whereby the review
Page 17.
petition- review application filed by the petitioner before the Central Administrative Tribunal Guwahati bench, seeking the review of the order dated 3/12/2012, passed in OA number 310/2012, has been dismissed. It is noticed that the issue raised by the petitioner before the tribunal regarding disbursement of the family pension to her it is to be noticed that the deceased father of the petitioner was serving in Shillong, in the state of Meghalaya, in Shillong, and the widow of the deceased employee has earlier approached the tribunal by way of filing original application OA number 310/2012 with the prayer to direct the respondents to pay her family pension after the death of her husband. Full stop. The tribunal wide order dated 3rd of December 2012 has directed the respondents in that OA to release the family pension in favor of the widow of the deceased employee. Full stop. The said order passed by the tribunal was subjected to challenge by way of writ petition.
71.
By way of writ petition by the mother of the deceased employee. However, by way of writ petition before the Meghalaya High Court by the mother of the deceased employee, however, the same has been dismissed and the order passed by the tribunal has been affirmed. Full stop. Taking into consideration the above facts and circumstances of the case, prima facie we are of the view that writ petition filed by the petitioner challenging the order dated 27th of November 2017, whereby the review application filed by her seeking review of the order dated 3/12/2012 passed by the tribunal in OA number 310/2012 is not maintainable before this court, before the Guwahati High Court. Learned counsel for the petitioner placed some time to satisfy this court regarding the maintainability of this writ petition before this court. How much time?
Soon after vacation, Lordship.
Just after 4 weeks.
Deep dive.
We are obliged. Silence is the best tool in the hands of the.
You realize it?
Item 225.
Yes, item number 2, I'm issuing for.
Have you filed that,
I have already filed, Lordship. It is not in
details regarding the specifications where
the details of the vending zones and when the phase 1 of the,
the locations and all.
yes, locations are already there. That is one list has been given as annexure A, Lordship. Your Lordship will find the 81 numbers of vending zones. Page 46.
Who is that service provider?
This is a one Indigenous Vendors Welfare India Association, Lordship. The name has been given there.
When they are going to file, whatever.
Lordship, the authority has given approval on 5/8/2024, Lordship, for their engagement. And they will, it is expected that they will submit their report, Lordship, very soon.
But by when?
That time has not yet been fixed.
Is absolutely vague.
I expect, Lordship, it will be very soon. Lord. General body was approval was on 5/8/2024, and thereafter they have been association has been engaged.
Time management. Vendors, they are conduct survey, allocate, looks after the monthly maintenance. Specific time. So once pass through works. I think you should come up with.
What is that 5/8/2084, 2024 order? It's not on record.
That is not.
Which one, Lordship?
5/8/2024. That order is not there. What are the terms and conditions? What duties or what responsibilities you have assigned to them? Where is
Yes,
that?
that order is not here. Lord. The engagement order is not here. It was approved only, approved only on 5/8/2024. Thereafter,
5/8/20, it's more than 1 month has passed. Only on what do you mean? And till this 1 month, what they have done? We have already engaged them.
not,
Whether they have prepared any plan or what they have done. It's incomplete, sir. It is incomplete.
not that part, they have not yet submitted their report. Lord.
That is. Then when they are going to submit the report? 2 years, 4 years, 5 years?
I
You've
will-
already identified, you have granted them the contract, then they should have come out with this.
Yes, Lord, it should have been.
Right, a proper affidavit. sir. 14/8/2024 was the order, and now after 1 month you have filed this affidavit, that is incomplete affidavit. It can't be. Okay, pursuant to the direction given by this court on 14/8/2024, and additional affidavit is filed on behalf of Guwahati Municipal Corporation. Stop. This court by the order dated 14/8/2024 has issued a direction to the respondents, to the GMC to specify the details about the 81 vending zones which has been established by it. It is further, it is also directed that the respondent GMC may also provide information that as to when, the phase one is going to start and what facilities in those vending zones to the street vendors as well as the public at large are to be provided. In the affidavit, in the latest affidavit filed by the GMC, a list of vending zones a list of vending zones declared by the GMC in exercise of powers conferred under section 18 in bracket 1 of the street vendors in bracket protection of livelihoods and regulation of street vending bracket close Act 2014 has been provided. In the additional affidavit, it is further mentioned that the GMC has engaged a service provider, namely Indigenous Vendors Welfare India Association, and entrusted it with the responsibility to develop build uniform design layout of all the vending zones and to allocate vending cards to the designated vendors. Full stop. The responsibility of fixing monthly maintenance, including water supply, electricity connection, timely cleaning, waste management, safety and hygiene standards, revenue generation for GMC, and protection against illegal encroachment, etc., has also been entrusted to the service provider. Stop. It is mentioned in the affidavit that the service provider was engaged by the order dated 5/8/2024. However, no such order is available on record. Full stop. It is also to be noted that though the service provider was engaged on 5/8/2024, but what action has been taken by it taken by it has not been elaborated in the additional affidavit. Full stop. We grant last opportunity to the counsel for the GMC to produce the copy of the order dated 5/8/2024, whereby the service provider is engaged for developing and maintaining the vending zones, and also to provide the details that what has been done by the said service provider after 5/8/2024. This matter of puja vacation. This matter on so and so. You provide all the details and ask the service provider to do it as early as possible.
What's a copy of the present application?
You are not supplying that. You can copy of the.
23rd of October. Item 6,
May I pray, Lordship? Lordship, I'm appearing for the Karbi Anglong Autonomous Council, Lordship.
Yes, item number 6.
Lordship,
Affidavit.
Affidavit 6.
Lordship, for Lordship, for respondent number 7, we have already filed, Lordship, for district sports officer, Lordship.
What about
For
the
respondent number, for
6,
for
11 and 12?
for 7, we have already filed, Lordship. For 6, Lordship, affidavit is ready, Lordship. We have sent it for waiting. Lordship. Only 10 days may be given, Lordship.
And what about 11 and 12?
11 and 12, Lordship.
Would be
It is not by us. Or
executive engineering has not. 12 months of time.
Respondent number 6, who is the respondent? number
Principal
six?
Secretary, Lordship. Principal
Principal
Secretary, Karbi Anglong Autonomous.
Karbi Anglong Autonomous.
So when you are going to complete this project?
5. There is a development in the other part. There is a initial visit from that was given and never project happened. And the new realization certificate has not been made, so the third installment has not. They have to do it. Yeah, because this is a schedule. They are coming. Yes.
11 and 12 are the executive engineer. What do you mean, the executive engineer, how they are? What to do? Okay. Learned counsel appearing for the respondent number 6 and 7 has submitted that an affidavit on behalf of the respondent number 6, respondent number 7
Yes, Lordship.
has already been filed. How,
No. Yes, Lord. For 7, we have already filed.
and has already been filed, and affidavit on behalf of the respondent number 6 will be filed
Within 10 days.
within 10 days. Let's start with Puja vacation.
Give the office. Lordship.
Item 7.
Please, your lordship. My lord, Lozima court order dated my lord 9/9 reveals that the my lord service regarding the respondent number 6 and 7 my lord has been completed.
Nikkei. As per the report from the Lalima Court dated 9/9/2024, service of notice upon the respondent number 6 and 7 is already complete. Yes, you are appearing for
Now 1 and 4.
1 and 4 only. Is this matter for admission?
Yes.
After Puja vacation.
Highly obliged, your lordship.
Item 8.
Respondent number 5 notice received and served.
My lord, steps was taken, my lord, but service
Answered,
not,
fresh, you take fresh steps.
my lord, my submission is there, my lord, humble submission, my lord. In 2019, my lord, tender was taken place, and my lord, 7 years time is going on.
Who is the respondent number 5?
Restaurant number 5, my lord, is a tenderer, my lord. The settlement is issued in favor of him, and he is operating the fishery.
Certainly, we have to hear her, hear that respondent number 5.
Let him come, but in the meantime, my lord, I may be operated because my lord, 7 years time is going to be over. Only 1 year time is left.
Maybe, until and
My
unless
lord,
we gave a hearing to. the
Lordship, may
respondent
kindly
number
see
5,
that-
How can we do that, sir?
my lord, total violation, page number 53, my
No,
lord.
but maybe we have to hear it.
My lord.
The aggrieved party is respondent number 5.
He is not turning up, my lord. In the meantime, time is going on, my lord. 7 years time.
But you have,
Only for,
you have to serve the notice upon the respondent number 5, otherwise we will not be
my
able to
lord,
help you.
may I take by Dusty, my lord.
Yes,
otherwise,
that's the AD, everything you take. As
only-
per the office report, notice upon the respondent number 5 received, answered. Learned counsel for the appellant is granted 2 weeks time to take fresh steps for service of notice upon the respondent number 5. On taking such steps, let notices be issued to the respondent number 5, returnable, registered AD and thus the returnable after Puja vacation, immediately after. Puja.
my lord, immediately after Puja vacation, my lord. Oblige, lordship.
23rd. Item 9.
Wait, Mr. Lord. But sir, I would like to praise, my lord, that in respect of 1 and 2, the memorandum of appearance is already on record. My lord.
No, we were required to take
What
step
about
that-
the other respondent?
Well, others have already appeared, my lord,
I am
just serve
appealing
them
for
copy.
3 to 7 lots.
3 to 7 and respondent number 1 and
Two, my lord, they have filed their memorandum of appearance.
click here. It's one concept of the petitioner. It's submitted that the notice upon the respondent, that memo has been filed on behalf of the respondent number 1 and 2 by, 1 and 2 by learned advocate. Mr. Kayal is appearing on behalf of the respondent number 3 to 8, 3 to 7.
7.
So this is therefore complete. Is this matter for admission?
Me.
Already into the admission, interim order to continue till next day.
I'm obliged.
Item 10,
Wait, your respondent number 7, who is for the respondent number 7? Private respondent. Will await return of the notices of
Yes, ma'am.
respondent number 7, await return of notice of respondent number 7 for 3 more weeks.
Obliged, madam.
item 11,
May I please, Your Honor? Respondent number 1 has not been served. Yes, sir. Await return of notice of respondent number 1 for 3 more weeks. Or 4 more weeks.
item 12,
Look, there is a
Only one
delay.
respondent is there. How many respondents are there?
There are, my lord, two respondents.
One,
One is a private respondent read petitioner, the other is a, my lord, Union of India is a, my lord, formal party. In fact, my lord, the private respondent, we have. served him.
respondent number 7 has not been served till date. Sorry, respondent number 1.
Respondent has been served, my lord, and they have, their name appears in the list.
12, na? 12, yes. Notice has been received till date, yes. Somebody has done it. And who is appearing for the Union of India? Who is appearing for the Union of India? It is. What's the matter?
My lord, this is regarding LPG distributorship in a particular location. My lord, there was a mistake in the, my lord, the identifying the, my lord, area. It was under a different subdivision, but mistakenly another subdivision was named. Therefore, my lord, the ISL authority decided to cancel it and, my lord, re-advertise it.
Fine. Then
Then it was challenged, the Honorable Single Judge said that that mistake does not make any real difference. That is what it said.
the IA comes upon for consideration of the. But the IA comes upon for consideration of the condonation of delay of 8 days in filing the connected appeal. Full stop. Notice upon the respondent number 1 has been duly served and the respondent number 2, Union of India, is also represented through Deputy Solicitor General. Solicitor General, whose name is also reflected in the cause list. In the cause list. Full stop. The name of the advocates appearing on behalf of the respondent number 1 is also reflected in the cause list. However, no one on behalf of the respondent is present and no affidavit in opposition of the application is filed. Having heard the learned counsel of the applicant and after going through the contents of the application, we are of the view that the delay of 8 days in filing the connected rate appeal is liable to be condoned. Hence, this IA is allowed the delay of 8 days in filing the connected appeal is condoned, registry is directed to register the connected appeal and listed for admission after 1 week.
Obliged.
Item 14,
May I please?
Yes.
Lordship, I'm appearing for respondent number 7, your lordship. Lordship, I beg some more time to file our objection, your lordship.
Okay, let consider applying for the respondent number 7. And what about the notices have been served upon all the respondents?
Yes, lordship.
Okay. Notices of the IA has already been served upon all the respondents. As observed by this court on 26/7/2024. The respondent number 7 takes some time to file affidavit in opposition to the application. Time frame for his granted response on. Yes.
item 14,
Here also, my lord, there is a little more delay in filing the appeal, my lord, 50 days.
Lordship, since on similar matter, delay has been condoned already, Lordship can do the same in this matter.
Okay, and the matter comes upon for consideration of the IA. Referred on behalf of the applicants with the prayer to condone the delay of 50 days.
50 days, my lord,
50 days in filing the connected appeal. Would stop. No affidavit in opposition is filed on behalf of the respondents. Despite service of notice, having heard the learned counsel for the party, and after going through the content of the application, we deem it appropriate to condone the delay of 50 days in filing the connected writ appeal. Hence, the IA is allowed. Delay of 50 days in filing the connected writ appeal is condoned. Registry is directed to register the connected writ appeal and listed after listed for admission after 2 year vacation.
Highly obliged.
item 15,
My This is the application for condonation of delay of 58 days, my lord. You are appealing on
Respondent 1 to 8, my lord. I'm not objecting, my lord.
the matter comes upon for consideration of the IA number so and so seeking condonation of delay of 58 days in filing the connected writ appeal. Counsel for the respondent has not seriously opposed the application. Having heard the learned counsel for the parties and after going through the content of the application, we deem it appropriate to condone the 58 delay, to condone the delay of 58 days in filing the connected writ appeal. Hence, the IA is allowed. Delay of 58 days in filing the connected writ appeal is condoned. Registry is directed to register the connected writ appeal and listed for admission after how many days after Puja vacation. In the meantime, writ appeal, you are in receipt of.
Yes, ma'am. Copy of the sir.
Fine.
Obliged, your lordship. 8.
for admission, item 16,
My lord, I am appearing for KBA.
No, please, your lordships. Lordships, this matter, the appellant has challenged the learned single judge in the order, lordship. But the
An application for vacation of the stay order before the learned single judge,
Lordship.
226(3) is already there.
lordship,
Why you have had this writ appeal?
however, the main case is listed on Monday, therefore lordship may kindly adjourn the matter for 1 week. Lord.
Why adjourn? Why you have filed this? File an application for vacation of the ex parte interim order.
Lordship.
Then only come if any or adverse order is passed against you. Okay. This writ appeal is filed by the appellant, being agreed with the order dated 6/9/2024 in 6/9/2024 passed by the learned single judge in writ petition number 4481/2024. While the order dated 6/9/2024, the learned single judge by issuing notices to the respondents has passed an ex parte interim order restraining the ex parte interim order and suspended the order dated 29/8/2024, whereby the fishery or market, what was this?
Market.
Where was the market? Was
Opposing
settled
weekly market.
in favor of the appellant temporarily for a period of 1 month. Full stop. We are of the view that the appellant has remedy to move an application for vacation of the ex parte interim stay order passed by the learned single judge by moving appropriate application under Article 226(3) of the Constitution of India. Hence, we are not inclined to entertain this writ appeal. The same is therefore.
However, Lordship,
Temporarily extended the settlement. Settled. मत करना. एक बार you just repeat them. Wide order dated 6/9/2024, the learned single judge, while issuing notices to the respondents. Whereby the market, whereby whereby extension was granted to the appellant for a period of 1 month in respect of settlement of market.
Lordship, liberty may kindly be granted if.
Yeah.
Liberty may kindly be granted to approach this court if there is.
We have already mentioned that. You have the opportunity, you can file an application. There is the question of liberty.
Item 17.
Yeah, please, Lordship. There in this case, my lord. On the basis of embarrassment, my lord. And I applied for the Anganwadi worker. I was selected. And I was appointed in the year 1915. They applied the private respondents filed a writ petition.
Why you not appeared before the learned single judge?
Yes, yes.
Nobody has appeared on behalf of you before the learned single judge at the time of hearing of the petition.
No, we appeared when the respondent didn't appear.
What's the petitioner?
Respondent didn't appear.
So they were.
Private respondent.
Oh, incredible. That is the. Practically, you are working till date.
Yes, sir.
After passing of the interim order by the learned single judge, whether you have continued to work or not.
Yes, still to, till today, my
Where
lord.
is that, sir? Where is the proof that you are working and you are getting some honorarium, some record?
Till today, we are working as a Anganwadi worker.
Where is that? From where we got that? From where we ascertain this, that you are still working pursuant to the interim order passed by this court? Returnable on 21. You are appealing for 1 to 6. Madam, you just ascertain whether these persons are still working or not. Because if they are working, then certainly they have some case, and if they are not working. No. Notice, Learned Counsel, appearing, Mr. Choi, accept notice on behalf of the respondent number 1 to 6, that notice be issued to the respondent number 7 to 10, returnable 2 weeks, registered AD Dasti. 3 weeks, and then returnable 3 weeks, registered AD Dasti. Learned Counsel, appearing for the respondent number 1 to 6, may apprise the court whether the appellants are still working. Appellants were working as Anganwadi worker till the disposal, final disposal of the writ petition on the strength of the stay order passed by this court, passed by the learned single judge in the writ petition from time to time. Yeah, in the writ petition, but time to time, in the writ petition.
Item 18.
Sir, we are filing the affidavit in this matter today.
Today, Mr. R. Majumdar, Learned Counsel, appearing for the secondary school education department,
Secondary education.
secondary education department. Has submitted that he is going to, he would be filing counter the affidavit during the course of the day. Full stop. And it counsel for the petitioner is granted time to file counter to the said reply of the secondary school education department if desired so by the next date of hearing, list after puja.
Obliged.
Item 19.
May please allow. Now, sir, matter relates to the recovery of excess salary, lordship, and the OA was allowed staying, allowing that we cannot recover. Lordship, one aspect of the matter that Rule 71 of the CCS pension rule has not been dealt with, in which we says that we can recovery from the gratuity. Lordship, can you peruse?
Yeah, now the law is well settled that if there is no fault on the part of the
That Chandi, Lordship, that matter is the Chandi Prasad Unial says something else. And moreover, the Lordship, there's other waiting for whom we are taking action, we'll be taking action, they will again come in.
See, there is no misrepresentation thought on your on their
That's
part.
true, that's
And
true, Lordship.
if even though if you erroneously paid to them,
That's
you are
true,
not
Lordship.
supposed to recover that.
That's true, Lordship, but that is not, that in case of only fraud, we can.
Issue notice.
Oblige.
Item 20.
CPSK. Eight.
Yes. No, sir, but there are two issues in this petition. But in the GST, but two returns are required to be filed. One is GSTR1, which is a return of the supplies. But the sales return invoice-wise detail is furnished by the supplier. On furnishing of the GSTR1, there is a auto-population in the GSTN portal of the buyer, wherein it is reflected in GSTR2A. The whatever sales is uploaded by the buyer within 10th of the month, but at that point of time, when the period of dispute. So in GSTR2A, it used to get reflected. So, my lord, the rule 36 was brought into force, 36(4) specifically, wherein a restriction was placed that you can avail credit only up to a certain percentage of the invoices uploaded by the supplier. Now, my lord, this rule drew its force from section 43, capital A, subsection 4. That section 43, capital A, subsection 4 was never notified. And without notification, my lord, this particular section itself was deleted from the books with effect from 1st of January 2022. And simultaneously, my lord, a section 16(2) was inserted in the act, which provided for a similar provision that until and unless, my lord, earlier it was a phased wise that earlier to start with, the restriction was placed up to 20% of the invoices uploaded. Then it was reduced to 10%, then it was reduced to 5%. But this rule 36(4), which drew its power from 43A was never notified. So subsequently, section 16(2) itself was inserted in the law, whereby no credit can be taken. My lord, so this was brought to at par with the whatever invoices are uploaded by the supplier, I can take credit only to that extent, nothing less, nothing more. So this came into force only with effect from 2022. So, my lord, now in this particular case, it is not that the invoices were ultimately not uploaded by the supplier. I furnished to the assessing officer the details that, look, in the month of, say, January, I took the credit more than GSTR 2A, but in, say, February, he uploaded the invoices. So ultimately, I become eligible to credit, if not in January, then in February, even though my submission is that rule 36(4), since it never, it drew its power from 43A. So for the
notified.
So for the period of dispute, no credit can be denied on the basis of 43, my lord, this rule 36. I am entitled to credit on the basis of section 16. Section 16 specifies 4 conditions that I must be in possession of the goods, I must have received the goods, it must be backed by the invoices, and I must have made the payment to the supplier. None of these conditions are challenged in the so-called notice. So as far as I am concerned, I have complied with all the conditions of section 16. Though it is a different matter altogether that in the order in original, the so-called notice is started with the violation of rule 36. But in the order in original, the concerned officer says that, look, you did not furnish me all the details and documents related to justify your claim of the credit, which he never in fact demanded from me. All that he demanded was reconciliation of my credit uploaded in GSTR 2A vis-a-vis my credit claimed in GSTR 3B, my return. So I explained it by way of a table, and he has noted it also, but discarding it, he has demanded the entire amount of the tax from me. And my lord, the second point is that he has demanded interest for delayed payment contrary to section 50 on the entire amount, including the credit amount as well as the case amount. He has demanded interest for the delayed filing of the return. So, my lord, here I have 2 points. So recently, there is a insertion of rule 88 capital B also in the law, whereby the law says that not only I am not entitled to pay interest on the credit portion, but if suppose I have paid the tax gradually and it is reflecting in my cash ledger, then to the extent that amount is available in the cash ledger, but the interest cannot be demanded on that portion just because I have delayed filing of the return, because, my lord, the amount is available in the kitty of the government. I have paid the tax.
That's right, but since now you have a statutory remedy of filing an appeal.
No, my lord, the appeal was dismissed as time barred. That is,
Where is that? When this was filed?
my lord, it was not time barred, in fact. That also, my lord, I will say.
Where is that appeal?
But my lord, that appeal, my lord, that appellate order is on page, my lord, 256 and 257. Kindly have a look.
Start from page 237.
It starts from 237, yes, ma'am.
No, his appeal, yes, And against this, you have a remedy to file an appeal under section 109,
102, 112.
112. Yeah.
No, but this has been dismissed as time barred without going into the merit. In any case, my lord,
Though if
My-
they strip
my lord-
it remedy,
no, my lord, what I submit is that there are two things, my lord.
Yes.
One is the, my lord, the interpretation of section 50. But secondly, my lord, this
There
rule,
is
challenge to the rule, my lord, I
That's
cannot
right.
avail the remedy.
That's right, sir. But once there is a statutory remedy, this court should restrain itself.
No, my lord, what I am submitting is that my statutory remedy can be against the order, but it cannot be against the rule, my lord.
Maybe, sir. But since you can very well raise all these points before the appellate tribunal.
No, my lord, but
There's
my
no
lord, the
one for that.
challenge to the rule 36 as it existed at that relevant point of time, that I cannot challenge before the tribunal, my lord.
Here you have challenged that.
Challenge that, my lord.
Yes, that's simply because you have challenged that rule 36. That doesn't mean something. Yes, you have challenged.
Rule 36, my lord, I have challenged, my lord. Kindly have a look at prayer, page 40, my lord. But there are couple of players, my lord, which are, my lord, can only be looked by the writ court, my lord, cannot be looked by the appellate court. But kindly have a look at my prayer on the page 42, my lord. Well, the second prayer from the top. And the first prayer also, my lord, cannot be looked by the tribunal, my lord. This prayer, my lord, that the writ in the nature of mandamus or any other appropriate writ or direction to declare that the GSTN portal not permitting filing of return in form GSTR 3B without full payment of tax is ultra virus, the CGST, SGST Act and CGST, SGST rules and is also violative of Article 14. This also, my lord, this prayer cannot be looked into by, my lord, the tribunal. And the, my lord, the last prayer also.
This option of challenging this rule 36 or whatever this
Yes.
was available to you when you have approached when you have submitted your case before the assessing officer.
No, my lord, but this is a,
It was
my lord, this is a
because
issue of-
how you have challenged this.
No, my lord.
After the order is passed, after the appellate authority has also passed it now.
No, my lord,
Only
that's
for
correct,
the
my lord.
purpose of this
My
maintenance.
lord, but
you have
my lord,
challenged this.
he has taken the ground. My lord, before the authority has taken the ground, but he could not have challenged the rule, my lord, before the authority.
At the time of initiation of the proceedings itself, you can very well
No,
challenge
my lord,
that.
that is, my lord, I bow down to that, but my lord,
So
my
that
lord,
reflects that it's
my lord,
simply
this is
for
a
the
issue of
purpose
jurisdiction, my
avoiding-
lord. My lord, the issue of jurisdiction can be raised at any stage, even before at the appellate stage, and my lord, it is a,
Jurisdiction so far as regarding this validity of the rule is concerned.
Yes, my lord.
This opportunity, this was, you are having that opportunity to do it. At the first instance, when the notice was issued to you by the assessing authority. You
that's,
have not chosen that and you have contested that matter before that. And now simply because to maintain this petition, if you have taken this ground.
no, my lord,
then
my lord.
We have. to-
My lord, right now, I'm not carrying that judgment, but my lord, there is a judgment of the Honorable Supreme Court which says that if there is a issue of the jurisdiction, but that it can be raised at any stage,
That is-
even after the appellate
that
order
is-
is passed.
that is The judgment, umpteen number of judgments are there. If the law point is there or jurisdiction issue is there, it can be raised at any stage.
Yes, madam.
That is there is no doubt about that. But looking to this, okay, you have opportunity and had the opportunity to challenge this validity of this rule
My lord-
at the first instance, you took your chance. And even up to the appellate.
My lord,
authority,
my lord,
now
the-
appellate
my lord,
tribunal provision is
general,
already
my lord,
there.
the general approach of any SSC is to try to resolve the issue at the first level first.
But
That is, my lord, that is what every SSC
that
tries to do.
It is not your case that at that time you are not agreed by this section
My lord,
36. and
my lord,
now
my lord, no SSC rushes to any advocate, my
The
lord,
problem is this.
at the assessment stage, my lord.
That
At the assessment stage, my lord, generally the chartered accountants who looks into the matter, my lord, they get the assess.
that is a question, but certainly you had the occasion for that. Now we have to look into this, first of all. Okay, file your, whatever it may be. File your reply.
Basic challenge of the petitioner is the appellate order only.
That is right, is right. File your counter to the petition, we'll consider. Notice. I'll accept notice on behalf of all the respondents. All the respondents. he may be allowed to file counter to the writ petition by the next date of hearing, based on after 4 weeks of puja vacation के just बाद का date.
But kindly give a specific date since I come from out.
We'll give specific.
Grateful.
24th of October.
24th of. Ju- Twenty-fourth.
Item 21.
May I please, Your Lordship? Milord, the petitioner has taken a loan, Milord. That was, an OTS was arrived at. And that OTS was to be paid within 6 months, but they could not. After 2 years, they could complete it. In fact, they have paid 4 lakhs more. Thereafter, they have initiated, issued notice under section 13(2) of Surface Act, Milord. We have filed a representation requesting them to absolve us from the loan after taking interest or fine for the delayed amount. That was not considered at all, Lord. And they are asking to pay the entire amount. That is why before your Lordship, Lord. So they at least they.
What is the illegality in the demand?
Otherwise, Lord, after.
What is the illegality in their demand? Their demand is not in accordance with law.
Yes, my lord, that is there, my lord.
That is there, then.
But they have to consider the plight of the petitioners.
Show us any law that they have to consider the plight of the show us any law on that.
Because we are ready to pay.
Go to the bank only.
Yes, we went there. We have filed representation, my lord.
Who gave the loan? Who advanced you the money? Who advanced you the money?
Bank, my lord.
Bank, and you are asking relief from this High Court. We have not advanced you the money. The money is of the bank. Public money.
My
We are
lord.
supposed to take action.
But under section, my lord, 13(3)(a),
Yeah.
they have to consider my.
Then file an application before the tribunal under section.
No, my lord, no, not like there, my lord. Kindly come to section 13(3)(a), proviso, my lord.
Yeah.
May I read, my lord? If on receipt of the notice under subsection 2, the borrower makes any representation or raises any objection, the secured creditor shall consider such representation or objection. And if the secured creditor comes to the conclusion that such representation or objection is not acceptable or tenable, he shall communicate within 15 days of receipt of such representation or objection the reason for non-acceptance of the representation or objection to the borrower, provided that the reason so communicated or likely action of the secured creditor at the stage of communication of reason shall not confer any right upon the borrower to prefer an application to the debt recovery tribunal under this section.
That is it. So doesn't confer, then doesn't confer.
My lord.
So far as regarding this loan recovery matter, the Supreme Court has deprecated this practice. We are not supposed to interfere in this matter.
Yes, my lord, but I am facing 13(3)(a), my lord.
Whatever.
And 13(3) proviso has cleared that because of non-consideration, I cannot go there, my lord. That is why I am before your lordship. That proviso
The respondent
kindly
will
be
not
looked into.
discharge
my
the
lord.
loan liability in terms of the OTS after taking reasonable interest and delayed payment towards the OTS in the form of loss incurred by so and so. Surfacing notice issued under shall be set aside. Section 13(2) surfacing notice you are challenging.
My lord, actually, I have challenged everything, but
Everything, then you raise all these grounds before the tribunal, not before this court.
my lord, at least that 3(a).
Where is that 3A? So Yes, my lord.
13(2), after rejecting their, whatever your prayer,
My lord.
if they have initiated proceedings under section 32, you can very well challenge that. Yes, certainly, you cannot challenge the decision of the bank authorities whereby your application for adjusting the amount or whatever it may be under section 33 has been dismissed. Against that, you can't do that. But against the proceedings under section 13(2), you can very well challenge the.
Yes, that part, my lord, my prayer number 4, my lord.
Go and do that one.
My prayer number 4, that may be looking.
Prayer number
Prayer number 4, my lord, that at page 19, my lord.
4.
4, my lord.
Yeah.
Directly responded to consider the representation that is so and so, my lord.
What is your representation?
My lord, that is, my lord, that is under, that is at page 64, my lord.
Yes. What is your representation?
My lord, that I have explained everything, what I have paid, that I have explained. And my lord, I have said that paragraph at page 66, my lord.
Yeah.
Under the aforesaid facts and circumstances, if your good self revoke the OTS and restore the liabilities of the entire loan amount, I shall not be able to bear such one year so and so. Therefore, I request you to absolve me from the loan liability amount after taking reasonable interest or for the delayed amount which will back from so and so, so and so. That they have not considered, my lord, at all.
Then consider it. We are not supposed to interfere in these matters.
Because they may be directed to consider at least, my lord.
No question of any direction. You press your application, and if they don't act, approach the recovery tribunal against the proceedings initiated under section 13(2). That's all. They are not supposed to interfere in these matters.
When they have issued
The
32,
complete
I have no right
mechanism
to go there. my
And a complete mechanism is there. Show us the authority of the High Court to interfere in these matters. What is that? Show us any law on this point. Yes, we can interfere in these matters, loan matters.
But at least, my lord, mandamus for that 13(3)(a), my lord. For that purpose.
Against that decision, certainly you cannot approach the deputy tribunal, but under section 13(2), the proceedings they have initiated, you can approach the tribunal. Under section 17.
When they will possess my property, thereafter only right.
Yes, certainly, and they're supposed to. Since you have not paid the money, now you're saying adjust this money and waive off all the loan. That is for the bank authorities. We are not experts in that. As per the terms and conditions of whatever the loan agreement, they have to act.
But my lord, their financial condition is so precarious, my lord.
That's why only you have not been able to pay. Then let them allow your property to be sold. You will be also.
No, that is
free from
the
all
only award,
liabilities.
my lord.
You will be also free from all the liabilities. That's why only they have taken this mortgaged your property. In case if you have not been able to, then they'll realize their money by auctioning that property. You can't have both the things in your hand. You will not pay the loan and you will also want to retain that property which you have mortgaged. That can't be done.
But at least they being a, my lord, authority, they could.
That is for them, not for us. Yeah, what do you want? Want to withdraw with liberty to approach the deputy tribunal?
Yes.
After attempting to argue the matter for quite some time, learned counsel on instructions has submitted that he wants to withdraw this petition with liberty to approach the deputy tribunal under section 17 of the Securitization and Reconstruction Finance so and so Act 2022, dismissed with liberty as prayed for.
Item 22.
Where please? The petition number before your.
Yes.
Petition number before your lordship is a association of tea producers. we have challenged the 2024 amendment to the tea marketing control order. The facts are like this, Mark. Initially, way back in 1984, if your lordship kindly turns to page 55.
Yes.
This in exercise of powers conferred by subsection 3 and subsection 5 of section 30 of the Tea Act, so and so, the following, the central government hereby makes the following order. Your lordship may kindly turn to page 57.
Yes.
At clause 17, this provision was made.
Yeah.
Sale of tea through public auctions. Every registered manufacturer in the states of Assam, West Bengal, Tamil Nadu, and Kerala shall, on and from the date of commencement of this order, sell not less than 70% or such higher percentage as may be specified from time to time by the board of tea manufactured by him in a year through public tea auctions in India held under the control or auspices of organizers of tea auction licensed to do so under the provisions of this order. So now they introduced this mandatory quota of 70% to be sold through tea auction centers. Now, this was amended to 75% subsequently, but ultimately it never got implemented. Now, in 2003,
Ultimately,
it was never implemented because there was large-scale objections, and they came up with another tea control order repealing this one in 2003, which your lordships will find at page 62. And the relevant provision, your lordship will find at page 70. This time they said
70.
page 70, clause 21.
Yeah.
Sale of tea through public auctions. Every registered manufacturer as specified by a direction of the registering authority shall from the date of commencement of this order sell such percentage as may be specified from time to time by the registering authority of tea manufactured by him in a calendar year or such period as may be specified in the direction through public tea auctions in India held under the control or auspices of organizers of tea auction licensed to do so under the provisions of this order. Now, this time they left it open as may be decided from time to time. This was amended to 70% at page 98. An amendment was made in 2015. And your relevant provision, your lordship will find at the next page, clause 5. At the very top, in the principal order in paragraph 21, for subparagraph 1 and the proviso, the following shall be substituted, namely, every registered botleaf tea factory, your lordship will kindly note this one, botleaf tea factory shall, on and from the date of commencement of the Tea Marketing Control Amendment Order 2015, sell not less than 70% of the total tea manufactured in a calendar year through public tea auctions in India, held under the control or auspices of organizers of tea auction, licensed to do so under the provisions of this order. So it was only bought leaf where this mandate was brought in of 70%.
Bought leaf and what is the bought leaf factory and another tea factory?
The ones who manufacture by themselves. There are two classes. One group of people, they manufacture it by themselves. They have their own setup, entire setup. And there's another group of tea manufacturers who buy the tea leaves from particular gardens. And
was this provision in relation to those persons who buy the
the ones from different tea gardens. Now,
not on the persons who are manufacturing that.
Yeah, absolutely.
And manufacturing and processing whatever it is.
Absolutely. Now this, if your lordship kindly, if your lordship kindly turns to page 101, a further amendment is made.
2000, the page?
At page 101.
101.
This gets amended. Now they bring in all registered manufacturers. Para 4 at page 101. In paragraph 21 of the said order for subparagraph 1, the following subparagraph shall be substituted, namely,
every registered tea manufacturer shall on and from the date of commencement of this notification sell not less than 50% of the total tea manufactured in a calendar year through public tea auctions in India.
It was reduced.
But this time they bring in all registered manufacturers.
So how it is
That
ultra-
includes, earlier it was only bottle leaf.
So how it is ultra virus?
No, I'm yet to come to that one. So this amendment comes in. Now, there was a lot of opposition to all these moves of imposing this embargo. Ultimately, at page 102, your lordship will find a meeting of the tea board. And in this meeting, at page 110, your lordship will find a resolution. Towards the middle of the page at 110.
Yeah.
Item number B13 of the board. Have my lords got it?
Yeah.
Proposal for routing 100% dust tea produced in the country through public tea auction. Some of the members expressed opposition to routing 100% dust tea through public auction platform.
This dust tea?
This is another variety of, it's the dust that gets produced during the course of manufacturing the tea. It was decided that on account of lack of consensus, the committee to be constituted for auctions shall look into the issue. Now there is a committee that gets constituted, and that constitution your lordship will find at page 112. There is an expert committee which is constituted for the specific purpose of looking into this issue of putting this embargo. This constitution your lordship will find at page 112. Now, even before this committee could act on it, submit a report, they come up with this impugned amendment, which your lordship will find at page 51. And your lordship will kindly see.
Yes.
This is again, your lordship will come to the second para. In the tea marketing control order 2003, hereinafter referred to as the said order, in paragraph 21, for subparagraph 1, the following subparagraph shall be substituted, namely, every registered tea manufacturer shall on and from the date of commencement of the tea marketing control order so and so sell not less than 50% of the total tea manufactured in a calendar year, excluding tea mentioned in so and so. Number 2, 100% of dust grades tea manufactured in a calendar year in its manufacturing units located in geographical area of states of Arunachal Pradesh, Assam, Bihar, Himachal, Meghalaya, Mizoram, Nagaland, Sikkim, Tripura, Uttarakhand, and West Bengal. Most interesting thing your lordship will note is that all the states in South India have been left out. It's only these states, and they have now put an embargo of 100%. They realize immediately that this is not possible to be implemented because the tea manufacturer will go bankrupt. They simply will have to surrender. What they do is now at page 53. First, may I draw your lordship's attention to page 52 first. On the same day that this amendment is carried out, they issue this simultaneously. In exercise of the power conferred by section 47 of Tea Act so and so, the central government hereby, page 52, sorry.
Yeah.
In exercise of the power conferred by section 47 of Tea Act 1953, the central government hereby directs that any power exercisable by it under section 30 of the said act, read with subparagraph 1 of paragraph 21 of the Tea Marketing Control Order 2003, with regard to specifying percentages, number 1. Number 2, geographical area of coverage and period of applicability may also be exercised by the tea board with prior approval of the central government. If I may pause here for a moment, your lordship will note that the geographical area has already been decided by amendment of the control order, and percentage also they have already decided that it is 100%. But they issue this. Thereafter, what they do is page 53.
Yes.
They absolutely, my lord, hoodwink us. The lordship will kindly see. In exercise of power conferred upon the tea board by order number so and so dated 23/2/24, The T board hereby specifies in consultation with the central government that the provisions contained in para 21(1) of the so-and-so order shall be applicable for a period of 3 months with effect from 1/4/2024. What they now do is they try to do it on a trial basis. We said, all right, for 3 months you want to do it. You will realize yourself that it is not possible to be implemented. Then we kept quiet. Then page 54, they have now extended it again by two months. But now we realize that basically they are playing with us. And that is how we have challenged the entire amendment itself on 2 grounds. Your Lordship is aware, Madam, encroachment under 19(1)(g) can be done only by way of 19(6). And what are the preconditions? If Your Lordship will kindly allow me to place that for constitution. There are the freedom envisaged in 19(1)(g),
Yes.
restrictions can be imposed only under 19(6). And Your Lordship will kindly have 19(6). Nothing in subclause G of the said clause shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interest of the general public reasonable restrictions on the exercise of the right conferred by the said subclause, and in particular, nothing in the said subclause shall affect the operation of any existing law insofar as it relates to or prevent the state from making any law relating to the profession, etc. We are not really bothered with this, my lord. What I am on is twofold. Firstly, it can be done only by way of a law made by either the parliament or the state. This is a control order. This is not a law made by the Parliament, number one. And number two, even the reasonable restrictions, Your Lordship is aware that right from the 50s, Supreme Court has been very clear that when you are imposing, you are encroaching upon the fundamental right guaranteed under Article 19, it cannot be, the doctrine of proportionality comes in. It cannot be an absolute embargo. On both these propositions, I'm placing to a few judgments.
Yeah.
Then find the response.
We are praying for a stay of this. But
We'll consider it after the response.
may I just, for my satisfaction, place two judgments? I'm absolutely covered. Firstly,
operation of law normally.
No, this is not a.
States.
That is what is my contention, my lord, before Your Lordship.
Yes.
For Your Lordship's consideration. But firstly, the law is very well settled that you can only do it by way of a law made by the parliament or the legislature. It is not. And secondly, my lord, their own language shows that the restriction imposed is excessive. It defies the doctrine of proportionality. In that case, my lord, Your Lordship will kindly make an observation that the interim will be considered on the next day. Otherwise will be seriously prejudiced.
Issue notice, Mr. So-and-so.
I appear for all the response.
All the respondents, yes, Mr. Arist Chaudhary. The Deputy Solicitor General accept notice on behalf of all the state, all the respondents, services therefore complete. He placed some time to file counter to the petition. Time paid for is granted.
Let it be after the vacation, Lordship,
It's on 28th of October.
that's fine.
28th of October 2024. for admission. The prayer for entering relief shall be considered on the next day.
Obliged.
Item 24.
Paid fees, Your Lordship. Lordship, this matter pertains to the promotion of a retired judicial officer to no, the perhaps. Madam. Notice, my lord, I apologize, my lord. Perhaps my lord may not like to take up my. Yes, yes, my lord.
First litigation.
In the writ petition, man, before the learned.
Filed by the petitioner.
By the petition, in this petition.
Earlier.
Earlier, previously, my lord.
Another bench. Yes. Put up before another reason, one of us, Mr. Punniga.
Deeply obliged.
Item 25.
May I please, Your Lordship? Lordship, in this matter, learned Advocate General will appear and he is on legs in court number 20. Lordship, pleadings are already been completed. Lordship may fix the matter for hearing.
Your Lordship may fix the matter for
Exclusion of one community, Jola community.
Lordship. They belong to Your Lordship Jolha community. They were brought from outside Your Lordship during in 19th century Your Lordship as a tea garden laborers Your Lordship. They are spread over both Brahmaputra Valley and Barak Valley Your Lordship. Now they have decided to Your Lordship keep the Jolha community residing in Barak Valley out of the OBC list Your Lordship. That's the issue Your Lordship. And that has been done in a manner Your Lordship without providing any opportunity, anything Your Lordship. This is the essentially the issue Your Lordship. Lordship, two other matters are pending. That Your Lordship, that challenges there Your Lordship. The first order is like this Your Lordship. The Jolha community being the community belonging to T tribe Your Lordship. There are 86 communities of T tribes Your Lordship in the OBC quota. Now for T tribe community, these communities there are special preferential treatment given by the state of Assam Your Lordship. Jolha was brought out of those communities belonging to T tribe, but they were kept as OBCs, Your Lord, but only in respect of Brahmaputra Valley, Your Lord.
That petition is also pending.
That is also pending, Your Lord.
Numbers, if we can provide
Yes,
the
yes.
Numbers I have.
But here, Your Lordship, issue is slightly different, Your Lordship. We have not challenged that original order, Your Lordship. Subsequent order has been passed, Your Lordship, by which, Your Lordship, these communities are the people belonging to Barak Valley were kept out of. So, Your Lordship, issue may not be the same, Your Lordship.
But more or less related to each other.
Yes, Lordship.
the petitioners, no, the petitioner in this writ petition has raised a question regarding the exclusion of the Jola community from the OBC category. Leading
Jolha community belonging to Barak Valley. Your Lordship.
belonging to Barak Valley. Jola community belonging to Barak Valley, also from OBC community. Pleadings, reply to the counter to the writ petition has already been filed and pleadings are complete. Let this PIL petition be listed for hearing. Admit nahi hui hogi na?
Lordship, admit, it is not admitted.
Admit. No need to issue notices, no need to issue formal notice as parties are already represented. List this matter for hearing after puja vacation.
Lordship may fix a date, your Lordship.
November, Lordship.
Take your date.
November.
Both of them, you please.
Lordship.
Item 29.
Twenty-nine, your Lordship, they have not filed their. They have taken time to.
There are quite some similar matters, my lord, which are pending.
Some?
There are similar matters which are pending, the same issue, my lord, whether the new pension scheme can be made applicable to the 2017 Provincialization Act. One of the petition is 1816 of 2019.
So that is segregated from that bunch.
That bunch, it has been segregated out.
Legal and Mr. Atmajumdar takes some more time to file counter to the writ petition. It covers 6 weeks.
Obliged.
Obliged.
Item 31.
After the last order on 6/9/2024,
You were supposed to visit that office.
yes, we visited there, my lord. We are asked to bring some documents, collect some documents like non-withdrawal certificate from the account. We have collected it. Again, we have gone there, my lord. Now the clients are in the office. Well, the outcome probably will be able to know, my lord, after few hours, my lord.
You are.
Because
They're
they are
coordinating, Lordship, we are cooperating, Lordship, only the.
Wednesday,
they are asked to Lakhimpur, my lord.
Wednesday,
Wednesday, yes, my lord.
Lordship,
this on Wednesday. You are hopeful by that time it would be resolved.
Yes, my lord. If
Wednesday.
much obliged.
Item 33.
May it please your Lordship. My lord, I'll be filing an affidavit, my lord, in this case. I have received my inspection.
You are
And for respond number 327, my lord. We have received some papers after that.
3 to 7.
Yeah, this is a writ appeal, my lord. My lord, in the writ proceeding, they have already filed, my lord, 150-page affidavit. They have filed reply.
My lord.
This is nothing but delaying the entire process, my lord, with all due respect, my lord.
My lord, if I may, my lord, there are certain developments which has taken place after the last order, my lord. I have that papers with me, but there's the key to file it through an affidavit, my lord.
By what time you will file the petition?
My lord, which time may be given to me, I'll be filing.
My lord, there is, on my part, my lord, there is some urgency in the matter, my lord. Let them file the affidavit by Monday, my lord. Lordship will take up on Tuesday or Wednesday. Because here, 3 students, final year students are before your Lordship, my lord, against the penalty order of expulsion, and the learned single judge rejected.
The offers are already with you. That's the only thing.
Lordship.
You are harping on that the placement has already, your placement is already settled, and on account of this now that that placement.
So far as.
So that time has already.
Yes. So far as 2 petitioners concerned, my lord, the offer, the time given by the company that has expired, but still there is a chance. That is my instruction. What, my lord, considering the fate of the writ appeal. So far, 1 petitioner is concerned, his date of joining was November. So hope is still there for.
Exams, this new, the exams.
The next semester started and it will end up in December pursuant to a liberty given by your Lordships, my lord. Without prejudice, we have taken admission, my lord.
My lord, if I may, my lord.
Yes.
Kindly.
Sure.
Yeah, yes.
My lord, my instructions are this, my lord, that they have again applied for the campus recruitment to the director. That is the papers which I have received, and while doing so, they have they've admitted certain things that they're not going to, they're not challenging the SDC verdict. That is the point, my lord, which I wanted to bring through.
This was,
This is the reason, my lord, I wanted some time to file an affidavit. I wanted to clarify this position from my client also, my lord.
Counsel appearing for the respondent number.
my lord,
3
may I
to
make
7,
a-
my lord.
my lord, may I make a small submission, my lord?
Just, we are granting them few days time.
Next week, my lord will kindly take up, my lord. Any date,
We'll try, yes.
any date in the next week.
You are appearing for respondent number
3 to 7, 3 to 7, my lord.
3 to 7. Praise, short time for placing certain subsequent developments. Short time
To file an
to
affidavit.
file an additional affidavit in respect of subsequent developments took place in the matter. List on
Any date in the next.
24th or 25th.
My lord, can we on 26th, my lord? It's not coming.
26th is the Saturday, sir.
Thursday.
Achha, sorry,
Thursday,
I'm
my lord.
looking at that October.
24, 26, my lord, any day.
26th.
My lord, please.
Highly obliged.
Item 35.
I have filed my affidavit in opposition here. We have received, my lord. I had sought from some instructions with regard to their contentions, my lord, which are yet to come. The matter may probably be admitted for hearing. In the meantime, I will get the instructions, my lord.
Having heard the non-counsel for the parties admit, no need to issue notice as parties are, no need to issue formal notices, parties are already represented. Let for hearing in due course.
All right.
For hearing, item 36.
Perhaps, my lord, OA file in the year 2000, my lord's name was there for the applicants. My lord. I searched, my lord, out of curiosity, and from old records, I found that in the year 2000, there was an OA file before tribunal.
In fact, the other day also, a lot of people not take up some matters because most of these casual level matters, somewhere or the other, lot of people appear.
I have to
I have reconstitute the bench.
take over my partner again.
Highly obliged, I'm sorry.
Item 37 and 38.
Yes.
Lordship. So for this concern, we have filed an affidavit.
What do you mean by file your affidavit regarding cabinet decision 15/3/2024, who is, you were supposed to take in last the opportunity to complete his instructions regarding cabinet decision 15/3, whereby the government has to follow one pay, one scheme for similar policy.
Yes, ma'am, there I already made the submission. That's why Lordship was pleased to, my lord. Yes,
What
ma'am,
submission
I
you
made
have
the
made?
submission, my lord. That's why Lordship was pleased to post it for hearing.
Department has submitted as a matter.
Yes,
of
I have
government
made
has not
already.
taken any decision follow. He submitted, it was agreed in the meeting, the Karmachari Parishad.
I placed
Meetings are complete in Acha, no need to issue.
Yes. Yes, otherwise it is ready for hearing.
Take it up immediately after puja vacation or not, for hearing or not.
The request of land concept of the staff of puja vacation. Yes.
Item 39.
Lordship, that's why seeks the indulgence of seeking an adjournment, Lordship, because of the voluminous nature. I could not prepare the case. I could not prepare the case properly, Lordship, just for an accommodation for the
Mr.
day.
Chakravarti, it's very strange. You are always ready with the brief.
Lordship.
What happened? Come visit there.
Lordship.
Where you were busy? Prepare you नहीं कर पाया.
Well, the question is a very short question of law involved here. The charge sheet was issued after 12 years and the tribunal has interfered.
Only on the ground of delay.
There is a ground of 12.
That can be a possible ground.
Lordship, that can be sometime in some cases that can be a genuine ground. But all the facts and circumstances has to be taken. I will cite some cases in which Supreme Court has stated when the allegations are serious, then it should not be. And in case of financial irregularities, it takes time to detect, Lordship. In between 3 court of inquiry was held, Lordship.
And Lordship, due to pendency of this case, I have been deprived of my promotion.
No, he has
I-
given two
Yes, sir.
promotion. He has given 2 promotion during this, after the incident.
After the patient.
Lordship, date may kindly be fixed.
Date, October,
7/11.
November में.
7/11.
Yes.